Okay, hello everyone, and welcome to our Wednesday, August 21st Planning Commission meeting. Can we have roll call, please?
Planning Commissioners Astorian.
Here.
Landrigan.
Present.
Lee. Manukian.
Present.
And Chairperson Yesayan.
Here. Report regarding posting of agenda, please.
The agenda for this meeting was posted on Wednesday, August 14th, 2013 on the bulletin board outside City Hall and on the city's website.
Thank you. Everyone, please stand up and repeat after me the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. All right, approval of the minutes. Do we have a motion or comments?
I move approval of the minutes of August 7th.
I second.
Great. We have roll call?
Planning
Actually, I don't believe there's a vote needed for that. Right, okay, good. Oral communications, I do not have any cards. You have one card for a case, but if anybody would like to speak for a case, please fill out a card and submit it. All right, number 6, Planning Commission orientation, excuse me.
Last time you continued this item for a full commission. However, we're still missing a member. I don't know if you wish to continue it again or if you'd wish us to proceed with this item.
I think Mr. Lee said he was going to be here, right?
He did.
So why don't he knows we were going to do this. Why don't we do this and then maybe someone can follow up with Mr. Lee later?
Sure.
Give him an orientation?
May I make a suggestion, though?
Yeah.
Can we, Mr. Chair, leave this as the last item so we can tend to people's business first?
Sure. Let's take it to the end of the
Thank
meeting
you.
then.
Okay.
All right, good idea. We don't want to keep you guys waiting. All right, so next item, Planning Commission items. Item number A, Street Alley Vacation Number 169B. This is for the portions of Arden Avenue and Bela Street. We have a staff report.
Yes, this is
Sure.
a vacation
Okay.
of Arden Avenue and Beulah, and the responsibility of the Planning Commission is to make findings regarding the consistency of the vacation of Arden and Beulah Street with the general plan. And in this case, it would be the circulation element of the general plan. These are both local streets. The vacation is at the southeastern corner of Arden and Beulah. This is a city project that has been undertaken to improve traffic flow, pedestrian safety, and to reduce traffic speeds. It will actually move the right-of-way or property line northwest, increasing the area of the two adjoining parcels that would be at 1620 Beulah Street and 1614 Arden Avenue. The vacation to the street would be consistent with the applicable goals and objectives of the circulation of the City of Glendale Comprehensive General Plan. And the purpose of making the changes is so you have more of a right angle when people make turns, therefore they need to slow down. And so staff recommends that you make a finding of consistency, and if you have any questions, I'll be happy to answer them. We also have the city engineer in the audience, Mr. Rubicolani, and to answer questions.
Do you have any questions? Yes.
I just have a comment. I appreciate the changes you're making, Mr. Galani, in reducing the width of many of these streets that are just like running across a freeway. And so this is a really wonderful, another one that we did up in the Montrose area that we just recently looked at. I'm pleased to see we're doing that. Thank you very much. It's really good for the safety of many of the kids and a lot of the other individuals who attempt to cross at these very wide areas. A great effort you're taking and succeeding with.
Okay.
I'm ready to move the item.
Great. Can we have the
Second.
motion?
Do you want me to read the motion into the record, or? So the consideration of vacation case number 169V, and the vacational portions of Orton Avenue and Beulah Street, and the vacational portion of the street should be consistent with the applicable goals. So I move to approve this vacation.
Second.
Okay, can we have roll call, please?
Planning Commissioners Astorian,
Yes.
Landrigan,
Aye.
Manukian,
Aye.
Chairperson Yesain.
Aye. Thanks. Next item is item number B, subdivision land tentative tract number 72219. Location is 124 West Colorado Street and 203 West Elk Avenue. And our staff report is by Mr. Kiesel.
Good evening, Mr. Chair and members of the Commission. The next item before you is tentative track 72219, a request to construct a 5-story, 50-unit condominium project on an approximately 22,000 square foot site in the DSP zone transitional district. The plans for the project, as well as a tentative map, are posted behind you, as well as some photos. The property is surrounded by the town center specific plan in the Americana to the north, the DSP to the east and west, with hotels on each interior side yard of the project, and then our 1650 multifamily residential on the south. The site has approximately 50 feet of frontage on Colorado and 100 feet of frontage on Elk, and is almost 300 feet deep. On October 9th of 2012, the City Council approved the Stage 2 design submission of the project, and an instrument imposing a covenant on the property because the applicant requested a 1-story and 0.5 FAR bonus for including additional public accessible open space in the project. You may remember this from about a year ago. You recommended the covenant. So you've seen the project before.
I remember seeing it before.
The project is consistent with the general plan as outlined in the staff report and complies with all the development standards contained in the DSP. The site is physically suited for the proposed type of development. As I mentioned in the staff report, the applicant is requesting an exception from the subdivision standards regarding the number of parking spaces. As noted in the staff report, the project does comply with the minimum number of parking spaces required in the DSP. It provides 84. However, GMC Section 1616.060 requires a minimum of 2 parking spaces per unit shall be conveyed with each residential unit, and obviously that's inconsistent with the zoning code. However, recent amendments to Section 16 approved by the City Council will rectify this inconsistency. That change that the City Council made doesn't go into effect until tomorrow. So this is kind of a cleanup. If you had heard this next week, there wouldn't have been an exception request. Unfortunately, the DSP parking standards got changed a couple years ago, and the subdivision standards didn't get altered to sort of reflect that.
Should we wait till tomorrow?
Well, I think probably the applicant would prefer an approval tonight with the exception, but you can certainly ask them. I would like to note there was an error in the staff report regarding the public schools. Children living in this future development will attend Cerritos Elementary and Roosevelt Middle School, not the schools I cited in the staff report. And then also, I made some additional changes to the conditions of approval that for Public Works. Basically, the change that was made separates out the improvements needed and required for Elk and for Colorado separately instead of including them all together. So the motion that was placed on your desk this afternoon reflects that change where the the improvements for Colorado are separate from the improvements from Elk. Based on the evidence, staff recommends that the Planning Commission approve tentative tract map 72219 with the attached conditions. That concludes my presentation. I'd be happy to answer any questions.
Questions?
I have none.
I have none.
It's been in front of us before.
Okay. Well, we have one card. Mr. Rodney Kahn.
Good evening, Chairman, Commissioners, and City staff. My name is Rodney Kahn. My offices are located on Brand Boulevard here in the city of Glendale. As staff mentioned, this project has been reviewed by you before. In terms of its site location, it's across the street from the Americana, and more specifically, it's directly across the street from the new Nordstrom building that's just been completed. Since the City Council approved our project on October the 9th of 2012, we have gone through the plan check process, and we're very close to getting our building permit. Mr. Historian, you mentioned about waiting one day. We would have been happy to wait one day, but what we were informed is the next opportunity we had to go in front of you was in about a month from today, and that's too long in terms of us being able to pull our building permit. So therefore, we wanted to continue with the hearing here this evening and respectfully request for you to approve that exception, even though we would be able to do it by right tomorrow.
It was rhetorical, Mr. Pong.
I wanted to answer it anyway. Anyway, having said that, the project, as we have designed, is consistent with the downtown specific plan and will be consistent with your Glendale Municipal Code update. With me this evening, I have both our civil engineer and our architect, so if you have any questions, we can provide answers. Thank you very much.
Questions?
No questions.
No questions.
Thanks.
Solid project. Looks like it'll be great for the area. Okay. If we have nothing, we can close the deliberation or go into deliberation. All right. Any comments?
No, I'm ready to move the project.
Well, please do so.
Does anyone else wish to discuss?
Second.
Okay. Can we have roll call, please?
Planning Commissioners Historian,
Yes.
Landrigan,
Aye.
Manukian, Chairperson Yesayan.
Aye. All right. Congratulations. Our next item is item number, or letter C, zoning code text amendment, case number PZTA 1311256. And this applies citywide. We have a staff report.
Chairman Yesayan, members of the Planning Commission, what this is essentially is it's an item to address some of the housing programs that were identified in the city's housing element and also in the analysis of impediments to fair housing choice. Those are two documents. One's required by the state, analysis of that would be the housing element. Analysis of impediments to fair housing choice really identifies where we have shortfalls in federal law. So between the two of them, we had a list of corrections that were directed for the city to implement. And as you can kind of tell by the staff report, they're kind of across the board. A lot of them have to do with definitions in the zoning code. When we adopt definitions in the zoning code, they generally come about because somebody has told us we need to have the definitions. If you look at the state law, there's a number of definitions that we're required to have. And when they go through our housing element, they look through, does the city have this definition? And over the years, we've added a number of them. We have currently we have about 15 different housing types that we have in our permitted use charts for zoning. And when you look at what the definitions require, there's some overlap. And the concern that both the federal government had and the state had is that when you look at these overlapping definitions, it can be confusing to somebody who wants to build affordable housing or is looking for a housing choice. So in terms of if you take a look at, we have prepared a chart. It's actually the second to the last page, I believe, on your, as a attachment. It's a, what it is it's an attachment that shows the different definitions we have for housing and what the characteristics are for the definitions. It is attachment, it's chart A, which is attachment 2 to the report, and it follows basically an outline, exhibit 1, where we have housing element analysis of impediment requirements. That's an attachment.
Wait, I'm sorry.
Right
Where's
after
this?
that.
Where's the attachment?
So the
It
definition.
would be page, it's behind, it's actually page 12 of the staff report. And why this is important is it just shows that these are all basically uses that we're required to have by the state, or either the state or the federal government. And then when you look at our definitions, there are some overlaps. So some of the same characteristics that you're required to have, for instance, if it's 5 or more people or 6 or more people, or if you're required to look at the number of beds to see if the use requires a certain length of stay. You may have a requirement for a common eating area. You may have a requirement that care is limited only to residents. You may have a requirement that under a definition your residents are ambulatory, or a definition where they must be post-surgery or medical use. So by the time you add all of them up, what it does is it makes it very confusing for anybody who tries to figure out what uses are allowed in our code. If somebody wants to come in with a use that we don't have in our code, for instance, a Ronald McDonald House, where do they fit in under the zoning? And the answer is they fit between a crack. They're not permitted in Glendale, although we have 3 hospitals. So you would think that we would be ripe for a type of use like that. So in order to address it, we worked with the state and we asked them, you're requiring us to have these definitions, yet when we put them in our code, they create inconsistencies. How do we address this? And they basically told us the same thing they told the rest of the cities in California. Well, you need to figure it out. So we called other cities, and they're the same boat we are. They have conflicting definitions. And we came up, and this was after months of just trying to figure out how did we do this. We said, well, maybe the answer is we simplify the use. Instead of having 15 different definitions in our housing permitted use charts, why don't we just go to 3? Let's take it down to what we really are looking for in zoning. What we're concerned about is the intensity of the use, how high is it, how tall is it, what kind of traffic impacts it has. Those are the ones that we can really address through zoning. And the rest of it, is it really all that, we're like, well, does it really have an impact that's in zoning? And the answer is probably not. So what we did was we used that list of the overlapping definitions. We said, okay, what uses have a parking impact? So anything where you're having a number of visitors, that's going to have a parking impact. If it's 6 or fewer people, the state's come in and said if it's 6 or fewer people, you can't require anything more than for a single family home. So when we looked through, we said, all right, we're going to create a lump in our big categories or umbrella categories. We'll provide 3 of them. We'll go with a residential congregate care, and that's the base category. And we'll say we'll call it residential congregate living. So it would be a new category, and it would include all the uses where we have basically 6 or fewer people or 1 household, and we'll lump them all together. Because the state's already said that we can't control if it's 6 or fewer and it's a single-family home. We can't control who lives in that house. There's a whole issue where they have people have freedom to congregate with whom they wish to. They can define their own household. So since the state has already spoken on that, we'll just we'll go along with the state, and we'll create 1 category for any 6 or fewer or 1 household. And that's what we did. Residential congregate, we called it residential congregate living limited. And then the other 2 categories we have is when you have group homes, essentially, that are larger than 6 people or 1 household. We said, well, what are the differences in those in terms of zoning? And the answer is, well, the real difference is, is it a use where it's medical care, or is it a use where it's not medical care? Are the people independent? Can they move around? And so we created 2 categories for that. We created residential congregate living non-medical, residential congregate living medical. So then we have taken everything down to 3 main categories. And that's what you'll see what we're proposing in our use charts. that we've attached. We have broken it down into the use charts for residential use, for commercial use, for industrial, and for mixed use. So that's the gist of why we were making the changes to the use charts and what we were trying to accomplish. We're actually trying to simplify the zoning use charts. So when somebody comes in, it sounds complicated, but we want to simplify it. So when somebody comes to the counter, it's easy for us to identify what type of housing use they want. If it's not a single-family home, any kind of group facility, how are we going to deal with it? It also allows us to compare the uses. So if somebody wants to do something that we don't have a strict definition for, they can have it if they fall under that category. For instance, if they do want to do a Ronald McDonald House, they can do it. Other definitions that we have to have under the state, we have to identify what uses are transitional uses and include a definition for that, so we've added that in the code. We have to provide a definition for supportive housing required by the state, and we've added that to the code. We also have to have single-room occupancy requirement. So we've decided that we used to have it in the code under hotel motel, that a single-room occupancy was that. We took that out a few years ago. The state asked us to add that back in, so we're proposing that be added back into the definition for hotel motel and single-room occupancy. And then the last change that we have is that
That single-room occupancy does not have cooking privileges.
no, generally not. It's just like a regular hotel or motel. They generally do not have kitchen facilities. And they are limited term stay, although we know people at times can renew the stay. They're limited to 30 days.
Right.
The other change that we're making or proposing to make is that we have to have a definition of disability that's required by the federal law. So we've used the definition that the federal government has identified with the Federal Fair Housing Act. And I think that goes over all the changes that we're proposing. However, we found that once, and also we have an issue that came up from our disabled community. What they're very concerned is that when somebody moves into a dwelling unit, that they're able to stay. If something happens to them, they become temporarily disabled, they're allowed to have assistants come in and help them. We know in single-family homes for a long time that's not been a problem. If somebody is injured, they come in and hire nursing care to come in and stay with them. It doesn't generally become a problem. But where we found more of an issue, at least it's been brought to our attention, is that it can be a greater issue in multiple family where people are renters. And if suddenly they're renting the house and then they hurt themselves and need to bring somebody in for assistance, a lot of times it's not really clear, are they allowed to have a service come in? So we are proposing modifications to both our dwelling one residential and our dwelling multiple residential, that we add a sentence that would say on-site support services, personnel, and equipment to maintain independent living is limited to residents of the dwelling. So people can come in, they can take care of people who are there. If you're living in a single-family home or if you're living in multifamily, you can call if you're injured and have assistance come to your house. And that way you're able to stay in your home. You don't necessarily have to relocate to another facility.
And so this was an issue?
was
It's very surprising for me to... that for example, in a multifamily residential complex, folks that had disability and needed that assisted living, they had an issue with this? I mean, there was real complaints about this?
Yes, there have been complaints, although Glendale isn't the city where this really comes from.
Yeah.
It comes from a lot of other cities, and when the disability advocates write letters on housing elements, they tend to write them to every city in the state. So regardless if your city has a history of it or not, there's a letter that's going to go to the HCD, Housing Community Development at the state, every time we submit a housing element or anytime we change our zoning. They look at it and they make these comments and they assume that everybody is, not all cities are like Glendale. We do recognize that there's a dignity to living and that we need to provide for a continuum of care where people can stay in their own units. But that's not always the case in a lot of cities, and it hasn't historically been. And so they take a very extremely conservative view when they look at the code they assume that the worst would happen in Glendale. One of the things they did ask us to do was, and it's in the report, is add a definition of family. Because traditionally, a lot of cities call it single-family homes. Now, we call it one residential dwelling, and we look at it by household, and we don't define that. People who live together, if they identify themselves as a household, we don't get into who's living there. But in the past, a lot of times they were identified by a family, and then there was a lot of questions on who exactly is a family. A lot of people coming from outside say, well, are they related? Are they unrelated? Well, Glendale avoided that completely because you get into a whole mess of civil rights issues by just saying it's a household. And if the household is happy living there and they're living together as a household, we're not going to get into if it's extended family or not extended family or if they're unrelated individuals. We basically avoided that so we could comply with the federal law. So when we took a look at the letter, it was a letter that was sent to a lot of cities. We got it too. It said you need to add a definition of family because they wanted to ensure that people who were unrelated could live together as a family. Well, in terms of Glendale, it makes no sense for us in our definitions of our code because we don't define anything based on family. And so we're not proposing we took definition of family out of Glendale's code years ago. And so while they told us to put it in, we studied it. We said we don't think we need to put it in because we define households, everything related to household, and then we don't have a number on how many people can be in a household. So it's not just immediate family. If people want to have whichever group that wants to live together and call themselves a family, they can do it. So that, I don't know if that sort of addresses one of the concerns that some of the disability advocates have, that we've addressed it, we've studied it. We don't think we need to make that change because our code allows flexibility for those households to live together, as people live together as they choose. We also, along with changing the zoning use charts, we are proposing to make similar changes to parking. So we have residential congregate living limited. Again, that's 6 or fewer. We're proposing to have 2 parking spaces, same as we would have for single family. For resident,
What is it now?
it's 2 parking spaces for a typical single family home. If the home's larger than 3,500 feet, then they have to increase the number of parking spaces to 3.
So what
So-
are you changing?
Well, right now, the requirement is 2 parking spaces, so we're proposing to keep it the same as 2 parking spaces, although our residential congregate living category has expanded. More uses that are in there. Under this new residential congregate living limited, we're proposing 2 parking spaces.
That's up to 3,500 square feet.
Up to 3,500 square feet. And then if the building is larger, then it would require more parking spaces simply because the building is larger. It is a
footage will
single-family
dictate.
home. Exactly.
And the congregate facilities, are they,
Those are essentially group homes.
and there's enough demand for 2 parking spaces for each unit for these facilities?
Well, actually, what we found in a lot of cases is they don't have a huge parking need. We drove around, we looked at the small family group homes in Glendale, we looked at them in Burbank, and we looked at them in La Cañada. And what we found is maybe at the most 1 or 2 cars. A lot of the people who live there are elderly, or they have some sort of a disability, but they're not driving. And so the people who are driving tend to be a staff person who's there perhaps giving care, and they may have one of the facilities we saw actually had a vehicle that belonged to the facility, actually belonged to several different facilities, and they shared it. But that was the only parking impact we saw. In fact, many of them nobody had a car, because even the people who were working there were taking a bus in.
Why,
so it was
why
very-
is it 2 parking spaces?
Well, because we are proposing 2, because they generally go in single-family homes, and that would be the parking requirement for a single-family home. And so we
By
just feel.
clustering this into one, you're taking the most severe application of it and applying it so that you don't have 5 or 6 different subcategories.
Right, and our goal is, again, it's to simplify the code, but we want to make sure we're not exacerbating a parking impact or a height impact on a neighborhood. That's where we really put our effort into it. How do we simplify the charts but not have a zoning impact that would impact a neighborhood? That was kind of the goal when we studied this. So for 6 or fewer, a lot of that's taken over by the state for group homes. We don't license them, but they are licensed by the state. And so we have many throughout Glendale that we don't know they're a group home. The state, they go directly to the state, they get licensed. We find out when we go online and we search for group homes or assisted living facilities, and then they come up and you find they're out throughout Glendale. So you don't realize how many we have until we actually look at it, because they're permitted directly by the state, not through planning. The other group we're looking at is residential congregate living, non-medical. And so for that one, we're proposing a parking ratio of 1 space for every 3 residents. That is the current ratio that we have for assisted living facilities if it's more than 7 or more people, more than 6 people. And so we're looking at continuing that parking ratio. If it's non-medical, it's not related to units because they may or may not have a unit. The requirement is that they have, we know that they have to have congregate eating facilities because that's what makes them a congregate facility or a group home. But it doesn't really make sense to use a typical multifamily parking ratio because that's based on a unit. So that, therefore, we looked at assisted living facilities to use that as the basis for the parking, 1 for every 3 residents. And then for medical uses, those are essentially like a skilled nursing facility or extended care or a convalescent hospital. And those are traditionally parked at 1 space per 4 beds. If it's a medical use, they usually use beds rather than people as being the way that we determine parking. And so we're actually proposing no change in that, in the parking requirement for extended care and skilled nursing or convalescent homes, although we would change the name, and the name would be residential congregate care living medical. I know it's complicated. It's very detailed. It took us months of studying and trying to figure out a way to make this work where we think we're having the least impact in terms of upon the neighborhood, but we can still comply with the zoning code requirements of the state and the federal law. I know this is a really long staff report. I appreciate that it's pretty hard to work through, but that was our goal. And Exhibit 1 actually shows the different, it's on page 9 to 11. It actually shows all the requirements that we have from all the different housing programs. We have Program 5E, 5F, 5G, and 6B, and then the analysis of impediments to fair housing, impediment 1, 3, and 7, and 12. All those are related to our definitions, and I believe we've addressed every single one of them through the changes that we're proposing. And you do have on the dais, we passed out a revised ordinance. From the one that was in your packet, we modified page 8. And page 8 has to do with the commercial uses, permitted use charts for residential. And what we had was, we were proposing to make a residential congregate living non-medical and medical a permitted use. However, we did have a group that was meeting on Monday nights to look at streamlining the code. And they've recommended that assisted living, which residential congregate living would fall under the assisted living category, they recommended that that be looked at as an AUP. So that would be an administrative use permit. So at this point, we're actually not proposing any changes to that. We did want to make it permitted, but since the group recommended that it be an AUP, we said let's make no changes to that. So when the streamlining goes to council, they can look at perhaps making that an AUP if they wanted to. This is running a little ahead of the streamlining effort. So that's why this isn't an AUP proposed right now. On page 39, we did have a modification to the definition of supportive housing.
Ms. Teller, on page 8, there are also some changes that I think you wanted to make, but you didn't want to make. We're not talking about. Oh, you're talking about this.
This is the revised one.
Yeah, we do have the housing uses that are being collapsed under the larger umbrella. We are proposing to eliminate again, to make the chart shorter so it's easier for people to understand it. So we are proposing to remove things like the residential congregate care facilities, senior housing, because they're all lumped under the other use. The only thing we did not change for senior housing was the parking. Right now, the parking for senior housing is one space for each unit, and we're proposing no change to that because senior housing really does have a different parking requirement than assisted living. Assisted living, you have many people who do not drive, but that's not true with senior housing projects. So the other change we were making on page 40 would be target population, and that is a new one. We didn't include that in your packet when we mailed it out. When we looked at the definition of supportive housing, we realized that there's an error in the one that the state told us to adopt. They actually the state changed their code, and they made references to target population. Therefore, we needed to have an ability to also have a reference in our code to a target population. And so that's why these changes were made essentially last minute. But that concludes my presentation. I hope I haven't completely confused you.
That was great.
Nicely done.
Very comprehensive.
I had a quick question.
I have an additional typo. Let me correct this. For supportive housing, we wanted to read...
Which?
This would be supportive housing on page 39 of the one that I passed out to you. Let me read it just to make sure we have it correctly in the record. Supportive housing means a residential use with no limit on length of stay that is occupied by the target population. I left the word population out. And that is linked to on-site or off-site support services that assist the resident in retaining housing, living independently, working in the community, and improving his or her health status. No services are provided to non-residents.
Okay. Mr. Manuki?
Earlier, you mentioned that you had spoken to other planning staffs from different cities. Is that accurate? Was there ever any sort of peer review done of this proposed cleanup, or no?
There was peer review done not only in the city, but then we did run the idea of through HCD, Housing Community Development. We do have a representative that works with us, and we asked him about just the concept of what if we do collapse all the uses and simplify it. We still have to have the definitions for many of the uses in our code, and we have not changed those. Those still would remain. But in terms of actually having a use chart that lists them, and the answer will, as long as you identify which uses are included within your umbrella, which we have through definitions, we're fine. And they actually liked that idea. They were actually very supportive of it, because then as the state changes definitions, which they constantly do, it gives us a tool where we can add them in the future without changing all of our permitted use charts. So when they tell us to add certain uses, which we know is coming because they're always changing them, it gives us more flexibility without impacting the development community. They already know what uses are under this umbrella. They already know what uses are permitted or not permitted or conditionally permitted. It wouldn't be a surprise to them every time we add another use. And we wouldn't have 15 uses in our use chart. We would only have a couple, and we would just need to figure out, okay, where does a new use fit in? So when somebody comes in and said, okay, we have hospice care, well, now we can fit that in. We don't have that use directly in our code, but we know where we can allow it.
So essentially, this is going to act like a converter.
Yes, exactly. That's exactly the goal that we have in there. We can't stop the state from creating new definitions and telling us we have to adopt them. But what we can do is give ourselves a tool where we can accommodate those changes as they occur in a way that's least impactful to us and our residents. And honestly, it's very confusing for housing providers when they come in and we have 15 different definitions and they're sliced so thinly. Somebody says, well, I want to have some units be assisted living, I want some units with skilled nursing and other units that are ambulatory. Well, we don't have an ability. It sounds pretty obvious that people should be able to be in one building and we should be able to transition the uses within a building. We don't have the tools necessarily to do that without suddenly requiring somebody to get conditional use permits where they didn't have it before. Right. So now this gives us a tool where we can actually have more flexibility that once you build it, and you have a use, there's more of ability for the use to modify without throwing them into a different category.
Good. So what's required from us?
So there's several motions on here, right?
Well, actually, I don't know what happened to the printer, but it gave you a lot of, there's actually only one motion, so it
Okay.
just printed several times, so I'm sorry
yeah.
about that. But it would just be the one motion.
Just one more question. Now, these proposed changes that are being made in no way or form are affecting anything else, say in the commercial zone or the others, because in your first packet, what permitted uses were in the commercial zones that were also included. I was wondering what the wisdom is behind that anyways. If we are only talking about these changes, why is it that I have to review the rest of that one page in there? That's why I'm bringing that up.
Yeah, it has to do with the way the ordinance is written. I give you the complete ordinance so you can see everything as it would be shown to the city council. The way it works is everything in those use charts, everything under that section, we have to include the whole thing. So you see, we can't just nitpick and only take out sections of it. If that is the whole section that we're amending, we have to include all of it in the ordinance. And so it's more of a technical requirement that we have it. That's why I tried to simplify it in the staff report, but unfortunately the ordinance itself is quite large because of all the other information that's in the ordinance, even if it's not related to housing.
Thank you for that.
Great. We have a motion.
Mr. Chair, the motion, if it is the Planning Commission's wish to include the recommended changes to sections 8, 39, and 40 as were read into the record and discussed,
Is that an
you
amendment?
should note that in the motion. Thank you.
Okay. There are no do you have any
No comments.
comments?
No,
There are
thank
no
you.
other comments. Can you get a motion?
Yes, Mr. Chairman. I move that the Planning Commission recommend that the City Council adopt the proposed ordinance amending the zoning code housing definitions, zoning permitted use charts, and parking in accordance with programs identified in the 2006-14 housing element and in the 2011-16 analysis of impediments of fair housing choice, case number PZTA 1221567. This project is exempt from the CEQA Class 5 exemption, and I would also like to include the material read into the record during the staff presentation.
Second.
Okay, roll call, please.
Planning Commissioners Astorian.
Yes.
Landrigan.
Aye.
Manukian.
Aye.
Chairperson Yasayan.
Aye. Thank you. All right. We will be going back to our Planning Commission orientation item. And is that you, Ms. Stotler? We giving it? Oh, okay.
The last time we brought a resolution to the Planning Commission was actually back in 2008. And so now what we're looking at doing is updating the resolution, just because we've had many changes in responsibilities for the Planning Commission. And also just departmental-wide, we're no longer the Department of Planning, we're the Department of Community Development. So many of those changes were just to recognize the new structure. So just to do a quick review for the duties of the Planning Commission. You are the decision maker for tentative parcel maps, new condominium tentative tract maps, use variances, special recreation zone review, ridgeline review, and bridgeline stream exemptions. You are also the decision maker on appeals from planning hearing officer and director decisions on variances, conditional use permits, parking use and parking reduction permits, and director reviews. And then your responsibility is also to make recommendations to the City Council on legislative items. We have general plan amendments, zone code amendments, zone changes, essentially anything affecting Title 30 will be brought to you for recommendation. Raw land tentative tract maps and any other matters that are included in the municipal code, such as one you saw today, which was the finding of consistency for street vacations. And as part of the resolution, we identify the order of the meeting. We've always, first we have public comment identified, appeals, old business, new business, planning division reports, and then planning commission comments. And just as I know you're familiar, the chairman may reorder any items. And then we just have a few issues that come up again and again, but not long, but just far enough for us to always forget what happens in the middle. So 3 members is a quorum. The chairman and vice chairman are elected each December for a 1-year term. If there is a conflict because of property or financial interest on behalf of one of our commissioners, then the commissioner does need to leave the room, and they will not count toward the quorum. And they also need to state why they're having a conflict, and you'll hear more about that. And then for appeals, we do have a quirk in the code that says we need 3 affirmative votes to reverse or affirm or modify a planning hearing officer decision, and that's because all of our hearing officer decisions are considered de novo. And that sometimes creates a problem when we have 2-2 votes. In those cases, the item automatically continues to the next meeting unless you continue it to a different date. And so that's just a quick overview. Now I'd just like to turn it over to Jillian and Yvette.
Thank you, Laura. Thank you, members of the Planning Commission. We will not labor our Brown Act presentation such that it becomes long and boring and tedious. Our plan is to make it a little bit interesting, so Yvette and I are going to tag team the presentation a little bit so you don't have one talking head, but a couple of talking heads to entertain you. Most of you hopefully are already familiar with the Brown Act, the sunshine laws that require basically government transparency, and that has to do with meetings, governs noticing of meetings, the conduct of meetings, and various other things. And those are the things that we'll be covering tonight on our PowerPoint, which hopefully you have a copy of. And that's entitled Brown Act and Hearing Procedures, and that is up on the screen. So I'm going to start off with a quote from the Government Code. And when does the Brown Act apply? It applies to all meetings of the legislative body of a local agency. Shall be open to the public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency except as otherwise permitted in this chapter. So the first issue is just what is a legislative body?
Good afternoon, members of the Planning Commission and Chairperson Yasayan. So what is a legislative body? Pretty simple. Obviously, City Council would be one, commissions, boards, committees, created by formal action of a legislative body, so that's the key. And one exception is ad hoc committees.
And typically ad hoc committees are those as opposed to standing committees that are formed of less than 3 members of the board or commission for a limited purpose, not as opposed to a standing committee, which would be for an ongoing purpose. Those would have to be noticed. The Act governs meetings, and so what is that? That's a congregation of a quorum of the members at the same place and time. That is the majority of the members of the legislative body, and this is what's important. It's both to hear, discuss, and deliberate on an item that's within the subject matter jurisdiction of that particular agency. So at times there are discussions that could range a little far afield from the Planning Commission's jurisdiction over the items that were noted by Laura that are within the bylaws of the Planning Commission, and that's when you may see myself or Laura step in to hem in the conversation to keep that on point. There are certain types of meetings that are prohibited, and I'll let Yvette talk about that, including the examples that follow.
So there's something called a serial meeting, and that type of meeting is prohibited. And what a serial meeting is basically where an intermediary or a technological device such as email, which is really common these days, is employed by the majority to develop a collective concurrence as to an action to be taken. So that's prohibited. So you may think that you're not developing a concurrence by just emailing each other, but you have to be careful when you're emailing each other that it doesn't suddenly turn into a meeting that is prohibited. Okay. An example of a serial meeting is Commissioner A emails Commissioner B, who then forwards that or emails Commissioner C, and then suddenly, even though you think there isn't a majority of the body talking, there suddenly is. There's the hub and spoke example, which is a variation on the previous example, which is that one member A talks to member B, and then member A talks to member C, and, sort of the intermediary in that sense.
I might add that intermediary might also be a staff member who is passing along the collective concurrence of two other members or another member, and suddenly there's a third member, and you have a quorum and a serial meeting that's occurred unwittingly outside of a public setting.
No, so this does not have a time frame attached to it. This can go over the course of a day, 2, 3, or months in that manner.
That's correct. If it has to do with a matter within the Planning Commission's subject matter jurisdiction that you're required to hear, discuss, or deliberate, it is a very slippery slope. It's easy for, in certain circumstances, the need for information, the lack of information, an emotional connection, or due to the excitement of an applicant, for example, can become infectious, and the sense of urgency can sometimes overtake conversations related to some of these items, and it can occur inadvertently. And so it's something we always have to be careful of when we are either having meetings with staff or conversations either in public buildings or in other places where you can gather acceptably, and we'll get to that. I'm sorry, there was a question.
My question is, if you have a deliberation and a decision has been made, and then there is an appeal period, if you talk about it afterwards and it comes back to you, have you violated the Brown Act?
If there's an opportunity for it to be remanded, you should not be discussing the matter even after the appeal has been heard.
But that needs constructive notice. In other words, if you're not aware of it that it's going to be remanded, then it's not a violation.
If there is a possibility that it would be remanded, I think the appropriate approach would be to avoid having subsequent conversations until that matter has been resolved through the City Council and whether or not that remand has actually occurred. That would be my recommendation to stay safe.
Technical question. In a hub or intermediary circumstances, is a member questioning the different members at different times? Does that also just questioning as opposed to statements or positions or what have you?
This is where it gets a little tricky because, and that's why I noted in that one slide that it says hear, discuss, or deliberate. Expressing an opinion, someone else is hearing that opinion, they're forming their own opinion based on what they've heard, which is instructing their thought process that they may pass along subsequent to that initial conversation. And that's how a collective concurrence or consciousness of a particular item can develop after that information is passed along. And therefore, it's recommended to avoid the possibility of that becoming a serial meeting when it pertains to a matter within your jurisdiction, a matter that's set on the agenda. So just to be very careful to avoid that possibility. And it happens very frequently, and it's natural for it to seem that it should happen, that you ought to have those conversations about these topics outside of a public meeting. But it's your collective conscience that is what the Brown Act wants to have undertaken and discussed and heard and here within the open setting. And that's what we're trying to develop here, so that the public at a noticed meeting can see, hear, and understand what you're deliberating, how you arrived there. They're entitled to do that, and that's what we're trying to avoid it through the serial meeting, the hub and spoke, or the intermediary type of meetings that can develop. So it is tricky, and any time that any of you have a question, I want you to feel free to contact either Yvette or myself, and we can discuss it. The same thing would of course, go for conflict issues. But let us get through this, and then if you have, maybe you want to, we can continue to take questions as the topics come
Yeah,
up.
let's finish up, and then
Yeah,
we'll save
okay.
the questions.
Very good. So do you want to go ahead?
So an action taken, so it's prohibited to have this sort of serial meeting to have a collective concurrence on an action. And an action is anything that's a collective decision, a collective commitment or promise can even qualify as an action, or of course an actual vote when seen as the body. Conversations, emails which advance or clarify a member's understanding of an issue, to facilitate an agreement or compromise among members, or to advance the ultimate resolution of an issue. So these, it seems pretty clear what an action is, but there are interesting peripheral sort of actions that you might not think are concurrence or actions, but they actually do qualify. One example that's illustrative of something that would be prohibited, Commissioner A, for example, sends an email to Commissioner B saying, I think I will vote to recommend the proposed ordinance. How about you? Also adding, by the way, I have C lined up and D is leaning my way. With your vote, it should pass out of commission. So clearly not a good thing. Okay.
No, go ahead.
There is a California case, Wolf versus City of Fremont, that holds that individual briefings of members of the legislative body is not a violation as long as staff does not act as a personal intermediary among the members. So staff can sit down with you and go over anything they want before the meeting, as long as they're not telling you what other commissioners are thinking or trying to get your opinions and pass it on to another commissioner. And then SB 1732, state law that clarifies this specific holding to make it clear that individual briefings are appropriate as long as staff does not communicate the views of any of them.
So the key here, again, is to avoid developing that collective concurrence, either directly or indirectly through intermediaries. And as staff, we try to do our level best not to encourage this to happen by disclosing those views, because certainly we could fall into that category as well and facilitate an action or a meeting outside of the public's purview. So it's that slippery slope of communication that we're trying to avoid amongst the members through emails or intermediaries. So let's talk about what a meeting isn't, because there certainly are occasions where you can be in the same room for certain events. And why don't you go ahead and talk about that?
For example, conferences that are open to the public where general issues are discussed, generally not a meeting. Community organized meetings that are open and publicized, and of course individual contacts with third persons are not meetings. Also attendance at open or notice meetings of another local agency or board, as long as you do not discuss amongst yourself issues of a specific nature that are not on the program. And you can go to a variety of social or ceremonial occasions. Those will not be viewed as a meeting. And anything where there's less than a quorum, that can't be a meeting.
And just to clarify a little bit on the conferences and seminars, the government code likes to specify that it's a gathering. It's not a subject to the Brown Act as long as the gathering is open to the public. So some of these private meetings, so even though, it's a conference seminar, but if it's not open to public attendance, you could run into a problem there. And so long as you're not all sitting together having a conversation in the back of the room, so it's something also to be careful of. And of course, social gatherings, et cetera, that were just mentioned. Let's move, and where there's less than a quorum. When two of you are together, that is not also considered a meeting, as you well know. So notice of meetings, regular meetings, Brown Act, traditional 72-hour notice. We need a special meeting. Those are available also to the Planning Commission. Sometimes we use those. That's a minimum 24-hour notice. And then emergency meetings, not typically required for the Planning Commission, and there are some fairly strict requirements related to that. It's usually a crippling form of an event, such as a natural disaster or other catastrophe. And we've had a couple of those meetings post-earthquake with the City Council. And so then there are particular noticing requirements, which fortunately are excellent. Planning Commission staff is very familiar with the government code and other code noticing requirements and where things need to be posted in order for the public to know just what it is that you'll be discussing, and to provide the information to you in writing, and also to make that available to the public. There are requests, written requests can be made to have information. Individuals can make a request to have information provided to them, specifically anything on a Planning Commission agenda when they are outside of the normal like posting requirements or radius requirements. So, for example, maybe a homeowners association in the north always wants to have notice of your agenda. They can make that request, and it's good for a year.
So the agenda has to have a general description of the item, and has to list each item to be discussed or transacted, and they must be agendas must be posted and accessible to the public. Have a variety of places that are various agendas. And obviously, I think well aware of this discussion of matters that are not on the agenda, with the exception of brief announcements, responses to comments, such that you see. And of course, if there is a need to act on something that necessarily couldn't be on the agenda because it's after the posting, that's
Public's access is very important under the Brown Act, and it can't be made conditional. What that means is a member of the public who wishes to attend the Planning Commission can't be required to sign in and provide their name and address. If they wish to address the Planning Commission, normally for the record, we want to know who the individuals are, and usually that is typically just so that we can make contact with them subsequently to provide information. But we can't make their attendance here conditional, charge admission price, or make them sign up in order to come in. We always include oral communications on your normal agenda, and we do, these are public hearings for the most part, and we will alert you in the event that there are public members here, they've submitted cards, and provide that opportunity. And we also recommend that you ask if any one member of the public is here to speak on an item. And everyone that I've worked with so far on the Planning Commission is very good at doing that, to make sure that they have the opportunity, the public, to address the legislative body on those general issues within your jurisdiction. There can be some control over that, as you know, if it is cumulative information, and normally you've also been very good at requesting the public not repeat comments that have already been made. So I think you're all very good at doing that, but that is also within your purview to control the amount of duplicative public comment that's made. We have to have thick skins, as you know, working in the public sphere, and so the public certainly is entitled to criticize policies, procedures, and programs of the agency, and the public can come in and otherwise tape or record it separately the meeting, so long as they're not disruptive and they cause a persistent disruption, a temporary disruption perhaps, but not persistent throughout the meeting so as to disturb your business. Want to talk about public records?
Sure. So we have to be careful because everything that potentially that you create, an email or a memo or a document, could be a public record. That's not to say you shouldn't feel free to email and create records, but just keep that in mind that it could potentially be disclosed to the entire public. So writings distributed to the majority of legislative body must be available to the public unless there is some exception to that under the government code that governs what is exempt from being a public record. If the record was distributed during a meeting by the agency, it must be available for the public inspection at the meeting. If there was something that was distributed inside of 72 hours, it must be available at the designated location. And also, we must make it available in alternative formats upon request under the American Act. Meetings. Next topic. Meetings outside of the jurisdiction, only under limited circumstances. Teleconferencing is allowed, but there's special procedures for that, noticing requirements for that. Meetings must meet the protections and prohibitions of the Americans with Disabilities Act, and secret ballots, unfortunately, or fortunately, however you look at it, are prohibited.
A note on teleconferencing. Sometimes there are members that are on vacation and are willing to join the meeting. If they are willing to do so, they can via a teleconference, so long as that is in an open and noticed location. I believe that the City Council has had calls from a wide variety of exotic locations in order to get business done on important matters. So if you have a question about doing so on an important matter, let us know. We'll help to facilitate that meeting should that become necessary. And our next topic is closed sessions. Not typically items come before the Planning Commission that would require you to go into closed session, although the Brown Act does permit closed sessions to occur on very limited topics. These are usually matters that are within the purview of the City Council, and I'll just mention them here for your edification mainly, and that is for litigation that's anticipated or pending. It must be noticed in a particular way unless it would jeopardize negotiations, labor negotiations, real estate negotiations. The negotiators are named. That's when we're for purchase, sale, or lease of property. Where there's a threat to public facilities or access, threat to public services, public employment, and a disclosure of the confidential information that is shared within those closed session meetings is unlawful and subject to penalties, which are covered in the next slide, and I'll have Yvette go over that.
Okay. So the penalties for a violation of the Brown Act, there are curative provisions, so they will give you an opportunity to cure. 90 days, the demand will go out, and 30 days to cure, and then 15 days to file an action if there is no cure. Civil actions to prevent, stop, or challenge actions, that's typically done by the district attorney. And there are attorney's fees available, so you have to be careful, potentially be paying out if we lose substantial attorney's fees. And it is for intentional deprivation of information to the public, and this requires a knowing violation, knowledge required. That is a criminal matter, so it is a pretty serious violate the Brown Act. In short.
In short, and that is why we always say that this is a transparency regulation to assure that the public has the information that is within the public's. That is the public's business before this body. One what you do is you hold hearings. And so there's a hearing procedure. There are legislative proceedings. That is what the city council does, is create law. And there are quasi-judicial proceedings, and those are most of the hearings that you have. These are de novo appeal hearings, and at which, under substantive and procedural due process, there must be a notice and opportunity to be heard. That's testimony and documentary evidence. Of course, the burden is on the appellant to prove that the evidence supporting the granting of the right of the permit is sufficient, and the decision of the Planning Commission needs to be based on evidence that's in the record. Site visits and ex parte contacts are typically not recommended. Because this information should be available to all of the Planning Commission members. And so when there's an ex parte contact with an applicant or an appellant, it can become problematic. So that's not recommended while an appeal matter is pending prior to your hearing. So that's the last slide that I have on our just very brief overview of the rules, the Brown Act, some of the duties of the procedures, and things that may come before you. I have a second presentation, which I think I'll hold for when we have a full Planning Commission, and that is on conflicts of interest, which gets fairly detailed. And so we'll hold it. So if you have questions for either Yvette or myself now, or at some later point, we're always available to answer those for you as we go through our process. Yes.
You mentioned African approaches to planning. It says may happen with time. Then, so if somebody actually asks us to come or makes an invitation to us individually through an email, our response should be that send it to staff. What would be the most appropriate response?
I don't know how Laura, the planning department, has handled those in the past. I haven't known of any problems that have occurred, but it's, as I indicated, not recommended that you do so, that you independently arrange for that visit, that you refer that matter to staff to obtain information for you that may be relevant for all of the Planning Commission to hear. And Laura can address how this procedure has been handled previously.
Right. I mean, at certain times we have arranged to have tours where we have taken the whole commission out to different sites. But we do give you the locations, and sometimes our understanding is that we do know people sometimes drive by just to get a view of it, so they know their surroundings. But it's different to drive by and so you know what you're talking about versus actually going on the site and doing an independent investigation, walking around. So
I think that's the distinction that we're talking
right. I
about
mean,
here.
We absolutely recommend that you drive by and at least see the neighborhood so you know where the house is, so it makes sense when you have testimony that you can put that into a location. But in terms of doing an independent investigation, no, we don't ask you to do that. When there are questions, though, sometimes we will have a commissioner ask us a question or want to have further information. We do make an effort to make sure that we send it to everybody. So if one person's requesting the information, suddenly you'll get an email from me that'll have, or from another planner that'll have a ton of information. You may be wondering, well, where did that come from? It's because we had a request, and we'll usually write in, we received a request for clarification, and we're adding this, or we have a request for a plan, or whatever it was you've asked. Sometimes it's a link to different, or a general plan, or something like that, and so we'll send it to everybody. And that's exactly the reason, the reason we do that is for transparency, so nobody has any different information than anybody else, and so everybody, when they come to a hearing, has an even playing field, so it's fair.
But if that information is provided at the hearing to the rest of the commissioners, is that still prohibited? I'll give you an example. A case of parking or lack thereof on a piece of property that is going to be coming in front of the commission. A commissioner decides to go out there, check it out for himself to see the usage of the parking, on street or off street, and how it is. Is that prohibited?
No, and that's the distinction. It is independently contacting or responding to a request from a contact from an applicant or an appellant, and there's a meeting on the site, as opposed to simply driving on the public right-of-way, orienting yourself to the location, driving in a commercial parking lot or an area that is otherwise open to the public, so that you can orient yourself to some of those concerns. So that's where the distinction, I think, lies.
So then if it's independent, investigation is okay. If it's, when it's not independent, then you have an issue, where Brownout has an issue with the investigation.
I think that what you're saying relies on what independent means. You are traveling by yourself independently to a site, as opposed to your going to the site is dependent on the invitation of someone who is meeting you there and who wishes to convey particular information to you.
Exactly.
Okay.
Thank you.
However, if we took it upon ourselves to independently confirm some numbers, that's not recommended.
Those sorts of technical questions, I think, are best directed to the staff for purposes of providing information to the entire Planning Commission, as Ms. Stotler indicated. And I will add, because it's important to note that lobbying is not disallowed. But as Ms. Nukian noted, we have to be careful of the Wolfe-Fremont case, which, while it's not, individual contacts or conversations, they're permitted, but it can easily develop into an intermediary situation, and that's little piece of
that would be considered lobbying.
Someone coming to you to provide information about a matter, that they have a proposal, they wanted to see what you're hearing about it. You have some information, and somehow that information, it's in your mind, you end up having that conversation with another commission member. There are two of you. It's not a quorum. It's not a meeting. But that information gets conveyed inadvertently because you've had that meeting with someone who's interested in developing something, a large project.
So Brown Act applies to California only?
The Brown Act is a California law. That's correct.
What you say sounds like it's getting violated every day by legislative bodies, because they talk to people all the time, and they talk to other, that's how they form opinions. They talk to groups. So I mean, we don't have that much contact
They
here.
talk to other people,
but
yes, and that's not disallowed. It's just the development of a collective concurrence amongst yourselves through the use of either amongst yourselves, through the use of intermediaries, through the use of electronic devices. It needs to be avoided so that hear, discuss, and deliberate.
But us and an applicant is okay.
Yes.
Right? Individually.
Yes. That applicant can also create Brown Act violations by doing what that example
Right. We're doing what a staff member could do.
Right. Or another commissioner could do. I have the vote of A and B. I think I can line up C. What do you think? And that sort of thing can happen very easily. And I would suspect that, as you indicated, happens frequently. But it is something that, this is what the Act requires, and we're doing our level best to ensure that this business within your jurisdiction is conducted in a transparent manner, open and public, and that's why we're doing this relatively brief presentation and having this conversation, so that it raises all our consciousness. And it happens very easily, as I said, and that's why we included, it is a slippery slope. The conversations happen very naturally. And so we just need to be conscious that this possibility is always there. It could occur at any time. And just to be careful, because we are human, and situations will change. Emotions can invade the conversation from the applicant, a sense of urgency, as I indicated, and it could influence the next conversation that we have that might be another commission member or staff member.
Thanks a lot.
You're You're very welcome. Please feel free to
putting that
contact
together.
us should you need more information.
If we can also have the electronic versions, that would be great. Or maybe make them available on the website.
Of the
So-
PowerPoint?
Yeah.
Absolutely.
And other PowerPoints. And a while ago, Mr. Garcia, who was here previously, did one on conditional use permits and findings, on how to come up with findings.
We would love to make that
Yeah,
presentation.
and
to you.
I thought that was very useful if the
I
commission
loved
would
that. That was very good presentation.
be
and
interested
very
to hear
helpful.
that. But I think that was very helpful, and also I think he touched on variances. But if that and you can use the same presentation, if that presentation can be made available on the website too, maybe an area where people can learn more about this stuff would be helpful for everyone.
We're happy to provide that information. We'll review it, and to the extent any cases have updated, anything that's relevant to that
Yeah.
presentation, we'll do that, and we'll
Exactly.
provide it to you.
Great, thank you.
With perhaps some emphasis on the discretionary powers of this body.
We're happy to provide that as well.
Great, thanks. All right, any updates from the Community Development Department?
Well, just that the first meeting in September has been canceled. It happens to fall on Rosh Hashanah, so the only meeting that we'll have in September will be the third Wednesday,
18th.
and it's the 18th. Also, just to let you know that you did see the Glendale Adventist Medical Center zoning that came before you last month. That is scheduled for City Council on September 10th. And so just if you're interested in following that item, I know that one's been scheduled. And I don't have any other updates.
Thank you, Ms. Dalton.
Thank you. Comments?
None?
Not for me.
All right, adjournment?
So moved.
Great.
Thank you.
Well, have a great evening, everyone.
Have a fabulous trip.
Thank you.